Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, in today's video, we are going to discuss all the questions of Contract Act which came in the exam paper of JHARKHAND Judicial Services from the year 2008 to 2018. I hope कि ये वीडियोस आपके लिए बड़ी यूजफुल रहेंगी. So friends, if you are preparing for judicial services, this channel will be very useful for you. आपके लिए बड़ा ही beneficial रहेगा. And अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. And don't forget to subscribe the channel. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. Next, 81. The principle of agency of necessity is applicable in emergent situation where communication with the principal is not possible. It is correct. Applicable in normal situation if the communication with the principal is possible. No. Unknown to the law of agency. No. A is the answer. Next, 82. A gives woolen cloth to B, a tailor, for making a suit. A tailor's charges are settled at rupees 500. The suit is ready. A tenders 500 to the charges, but the tailor refuses to deliver the suit till A pays all dues. In such case, B cannot refuse to deliver the suit. B is the answer. अगर ओल्ड ड्यूज है तो उसके लिए अलग से केस करना पड़ेगा, बट इसके लिए मना नहीं कर सकते. बी इसका आंसर रहेगा. नेक्स्ट 83. विच ऑफ द फॉलोइंग इज करेक्ट? Pledge made by a person having a limited interest is valid to the extent of that interest. बिल्कुल ठीक है. ये मेंशन किया गया सेक्शन 179 ऑफ कॉन्ट्रैक्ट एक्ट में. फिर प्लेज मेड बाय पर्सन अंडर वर्डेबल कॉन्ट्रैक्ट इज वैलिड. ये देखिए, ये जो है कंडीशनल है, ये परफेक्टली ये मैं कहूँगा कि आंसर नहीं बनेगा. क्यों? सेक्शन 178 में मेंशन किया गया है अगर वर्डेबल कॉन्ट्रैक्ट में है और उस जो वर्डेबल कॉन्ट्रैक्ट को रिसेंड नहीं किया गया है और पोनी ने जो है एक्वायर किया है टाइटल इन गुड फेथ, तो जो वो प्लेज जो है वो वैलिड रहेगी. फिर प्लेज मेड बाय मर्केंटाइल एजेंट इज वैलिड. ये करेक्ट है. ये मेंशन किया गया सेक्शन 178 में. फिर गुड्स में बी प्लेज बाय सर्वेंट इन द एब्सेंस ऑफ द ओनर. नहीं, ये रॉन्ग है. सो इसमें देखिए, मैं कहूँगा कि ये 3 आंसर हो गए. अगर ये कंडीशनल नहीं होता बी तो ये भी आंसर ठीक हो जाता है, बट सी और ए तो आंसर इसमें है ही है. तो मैं ये कहूँगा कि ये भी क्वेश्चन जो है ठीक नहीं हुआ. Next, 84. The liability of the surety is coextensive with that of principal debtor unless it is otherwise provided by the contract. Is correct. Totally correct. Now, reason is any variance made without the surety's consent in the terms of contract between the principal debtor and the creditor discharges the surety as to transaction subsequent to variance. It is correct. So both are correct. इसका आंसर रहेगा A. Both are correct, but it is not the correct explanation of A. क्या इसका रीज़न हो सकता है? दिस इज अ फैक्ट. इसका रीज़न नहीं है, तो बी इसका आंसर रहेगा. ये भी एक फैक्ट है, ये भी एक फैक्ट है, बट क्या जो रीज़न होना चाहिए वो रीज़न नहीं है. अदर्शन इज सेक्शन 128 एंड द रीज़न दिस इज सेक्शन 133. बोथ आर पर्टिकुलर प्रोविजंस. Next, 85. A, without the request of anybody, extinguishes the fire of godown. A suffers injury thereby. B promises to compensate A for the whole amount he has spent for his treatment. The contract is enforceable. D is the answer. It will fall under exception 2 to section 25 of Contract Act. Next, 87. X, a trader, leaves good at Y's house by mistake. If Y uses the goods, then which one of the following is correct when X demands the price for the goods and Y refuses to pay? Y is not bound to pay as he becomes the owner of the good left at his own wrong. Y is bound to pay as X did not intend to supply the good gratuitously and Y enjoyed the benefit of X's act. This is correct. And this is illustration A to section 70 of Contract Act. This is section 70. X is not bound to pay. Wrong. So B is the answer. Next, 88. X contracted with a tent house for erecting a shamiana for performing the marriage of his daughter. On the day of marriage, a curfew was clamped in the area preventing the celebration of the marriage. The shamiana owner claims the charges agreed to paid by X. In the light of the above, which of the following is correct? X has to pay the contracted damages. No. Need not to pay the but only reasonable charges. No. X can require state to bear the claim, या फिर X need not to pay anything as celebration of the marriage was impossible on the count of curfew. D is the answer. Doctrine of impossibility would be applicable as per section 56 Contract Act. So D is the answer. You can take also the example of Krell versus Henry. Next 89. In which of the following instances has the discharge of agreement not been affected? A promises to paint a picture for B. B afterward forbid him to do so. It is discharge. A owes B rupees 5,000. C pays to B rupees 1,000, which B accepts in satisfaction of his claim against A. It is correct. A awaits arrival or B to finish the painting for B. There is no discharge because he is waiting, है ना? A owes B rupees 2,000 and is also indebted to the other creditors. A makes an arrangement with his creditor, including B, to pay them half of the loan amount. A pays B rupees 1,000. This is correct. So C is the answer in this case. No discharge. No discharge of agreement has been effected. Next is 90. A contingent contract based on specified uncertain event not happening within a fixed time. Okay, this is section 35, part 2. Can be enforced if the event does not happen within the fixed time. Cannot be enforced at all. Wrong. Can be before the expiry of fixed time. It becomes certain that such event shall not happen. It is correct. Either you get the information before expiry or till that time fixed for performance. So both are correct. A and C. D is the answer. Next 91. Which one of the following is a contract? Agreement to do lawful act by unlawful means. It is not contract. An undertaking in writing duly signed to pay a time barred debt. This is a contract. It is exception 3 to section 25 Contract Act. An agreement restraint of lawful trade. It is void as per section 27 Contract Act. A agreement to pay rupees 10,000 without consideration. It is void. This is illustration A to section 25. So B is contract. B is the answer. This is 92. Which one of the following is not provided in section 4 and 5 of the Contract Act? Communication of offer. Communication of acceptance is there. Revocation of proposal and acceptance is there. Revocation of contract, no, it is not there. So D is the answer. Next is 93. Which one of the following does not amount to fraud? Active concealment of a fact. It is a fraud. It amounts to fraud. Promise made without intention of performing it. It amounts to fraud. Suggesting as a fact of that which is not true by one who does not believe it to be true. This is correct. A representation made without knowing to be false, honestly believing it to be true. This is not fraud. So D is the answer. Section 17 of Contract Act talks about fraud. Next 94. A stipulation for increased interest from the date of default is known as penalty. B is the answer. Next 95. Now you have to match the list. Tin versus Hoffman. It is on cross offer. Fisher versus Bell. Invitation to treat. This is a repeat question actually. Carl versus Carbolic Smokeball Company. Offer at large. Hare versus Facey. Quotation of price. So क्या बन गया इसका? 3124. So this question was actually deleted because the options were not proper. ऑप्शन इसमें थे ही नहीं. 3124 बनाई नहीं कहीं पर भी. Next 96. Which one of the following proposition is correct? A minor's agreement being void, a minor is not bound to pay for necessities supplied to him. No, wrong. Minor's contract being voidable, he is bound to pay. Wrong. Minor is bound to pay for necessities supplied to him because a minor's contract is valid. No. A minor's contract is void, but he is bound to pay for necessities supplied to him. It is correct as per section 68. So D is the answer. Next 97. Again match करनी list को. Supervening impossibility is called frustration. Consideration is quid pro quo. Good faith. It means utmost faith. Ubrima fides contract. What is the meaning of ubrima fides? Utmost faith. Dunlop टायर एंड सेल्फ रिजिस को किस पर है? ये प्रिविटी ऑफ कॉन्ट्रैक्ट पर है केस. तो क्या बन गया? 2413. 2413 is there. C is the answer. Next is 98. Assertion is brokerage contract is valid. It is correct. Reason is brokerage contract is opposed to public policy. No, it is not. So A is true or is false. C is the answer. Next 99. Which of the following are duties of bailee? Duty to take reasonable care of goods. It is correct. It is provided in section 151 of Contract Act. Then duty not to make unauthorized use of goods. It is correct. Not to mix his own goods with goods bailed. It is correct. Duty to compensate when goods are damaged despite of the care of bailee. No, it is not. So 1, 2, 3 are correct. B is the answer. Next is 100. Adamson versus Jarvis is leading case on. It is on contract of indemnity. B is the answer. Next 69. Which of the following is not essential for a consideration? It must be given at the desire of the promisor. Yes. Valuable. Yes. Lawful. Yes. Adequate. No need to be adequate. D is the answer. They're asking not essential. Consideration is defined where? Section 2D of Contract Act. And agreement without consideration is void. It is mentioned in section 25 Contract Act. Next 70. The provision relating to contingent contract under the Indian Contract Act is laid down under section 31 to 36. C is the answer. Next 71. The intimation under section 59 of Indian Contract Act must be implied or expressed. May be either expressed or implied. C is the answer. Next 72. A tender in a newspaper is an invitation to offer. A is the answer. Next 73. Every promise and every set of promise forming the consideration for each other is known as agreement. A is the answer, and it is mentioned where? Section 2E of Contract Act. Next 74. A agree with B to discover treasure by magic. The agreement is void. B is the answer. And this is illustration A in section 56 of Contract Act. Next 75. Which of the following section of Indian Contract Act defines contract? It is 2H. A is the answer. 2F is reciprocal promise. D is consideration. A is proposal. Next 76. Which of the following section of Indian Contract Act defines consideration? I just mentioned it. So it is in 2D. D is the answer. A is proposal. B is promise. C is who is promiser and promisee. Next 77. An agreement without consideration is void. It is laid down where? In section 25, subsection 1. D is the answer. 2D is definition of consideration. 23 is unlawful object and opposed to public policy. And section 10 is about what is contract. Next 78. The nature of an agreement made under the provision of section 20 of the Indian Contract Act would be void. B is the answer. What is section 20? When both parties at mistake. Next 79. The liability of the surety is coextensive with that of principal debtor. It has been provided under section 128. C is the answer. 126 is what is guarantee, creditor and surety. The definitions. Next 80. An agreement to do an act impossible is provided in Indian Contract Act under section 56. C is the answer. Next 81. The contract of pledge is a contract of bailment. C is the answer. It is provided where? In section 172 Contract Act. Next 83. A who deals in coconut oil enters into an agreement with B to sell 50 tons of oil. The agreement is enforceable by law. A is the answer. Next 84. B is wife of A. A during lifetime of B and with her consent makes an agreement with C to marry her. The agreement is void. It is barred by law, है ना? So A is the answer. And 37. In case of anticipatory breach of contract, an aggrieved party has a right to claim performance at any time, or cannot claim any remedy if may wait till the date of performance, has right to claim performance at any time, and also does have right to claim to terminate the contract, and it is mentioned here does not. So these three are incorrect. A is the answer. And where is the provision for anticipatory breach in Contract Act? It is in section 39. Next, 38. Which of the following statement is not correct? Acceptance must be communicated. Yes, obviously. Must be in writing. It is not necessary. Oral acceptance is valid. Acceptance, yes. Must be in a prescribed manner. Yes, it is correct. What is not correct? B. B is the answer. Next, 39. The principal restitution stops where repayment begins. Can be applied against an alien enemy of an incapable person, lunatic idiots, minors. Minors only. D is the answer. Next, 40. Promissory estoppels is sometimes spoken of as substitute for consideration. B is the answer. Next, 41. A change of nature of obligation of a contract is known as novation. D is the answer. If it is mentioned that a change in nature of obligation in a contract, then it would be alteration, because the change is made in the contract and not the whole obligation has been changed. If the whole obligation has been changed, then it is novation. If the only part of obligation is changed, then it is only alteration. So you need to understand this. Next, 42. A notice in the newspaper inviting tender is invitation to proposal. C is the answer. Next, 43. Examine the following statements. Every contract is an agreement. Yes. Every agreement is a contract. No. Every lawful civil obligation is a contract. No. Every contract has legally enforceable civil obligations. Yeah, it is correct. So 1 and 4 are correct. A is the answer. Next, 44. Union of India versus Mandala Tathaiya is an illustration where tender was in form of standing offer. B is the answer. Next, 45. The rule laid down in Adam versus Lindsell was approved by the House of Lords in Dunlop versus Higgins. A is the answer. What rule they applied? Postal rule. The main base of postal rule is this case, Adam versus Lindsell. Next, 46. Which one of the following agreements is held to be opposed to public policy? The arbitration clause for application of foreign law? No, it is not. Payment in foreign currency? No. Agreement of payment less salary? No. Yes, it is against public policy. Arbitrator residing in foreign country? No. So C is the answer. Next is 47. The fact of Griffith versus Bremer would attract section 20, and facts of Krell versus Henry attracts section 56. Doctrine of frustration, doctrine of impossibility. D is the answer. This is coronation case, na, Krell versus Henry. Next, 48. The obligation to restore advantage in a void agreement is provided by section 65 of Indian Contract Act. A is the answer. Next, 49. A continuing guarantee under section 130 is irrevocable. Absolutely. या फिर revocable. Absolutely no. It is revocable as regard to future transactions. B is the answer. Next, 50. For the purpose of pledge, delivery of possession of goods may be symbolic or actual. It has to be actual, not symbolic. D is the answer. Next, 51. A valid lease can be determined by force majeure, frustration, afflux of time. Usually by afflux of time. C is the answer. But I would say this is a controversial question. Next, 52. There can also be sale by estoppel if ownership by fraud possession. Sale by estoppels. A is the answer. Next 69, the case of Harvey versus Facey is related with offer and invitation to offer. A is the answer. Bumper Hall pen. Remember this case. Next 70, in which of the following case it is said that public policy is unruly horse? In Adam versus Lindsell. Richardson versus Malish. B is the answer. And said by whom? Justice Borough. Next 71, the case of Mohari Bibi versus Ramdas Ghosh was decided by Privy Council in the year 1903. C is the answer. Next 72, an agreement on the happening of event, impossible event, is void under section 36. D is the answer. And 73, which of the following section of Contract Act is related with the novation of contract? That is section 62. A is the answer. Next 74, the case of Satyavrat Ghosh versus Mugniram is related with impossibility of performance. C is the answer. Next 75, promises which forms the consideration or part of consideration for each other are called reciprocal promise. B is the answer. And where this is mentioned, it is mentioned in section 2F of Contract Act. Next 76, the case of State of West Bengal versus BK Mandal is related with quasi-contract. D is the answer. Next 77, which of the following section of Contract Act is related with the anticipatory breach of contract? That is section 39. A is the answer. Next 78, A promises for no consideration to give to B rupees 1000. This is a void agreement. Agreement without consideration is void ab initio. C is the answer. And this is illustration in section 25. Next 79, a contract to pay rupees 10,000 if B's house is burnt. This is an contingent contract. D is the answer. And this is illustration in section 31 of Contract Act. Next 80, which of the following section of Contract Act define bailment? 148. A is the answer. Next 81, which of the following statement is correct? Agent is defined in section 183 of Contract Act. No, it is defined in 182. Any person can appoint agent. Yes, but major person shall appoint. है ना? फिर consideration is necessary to create an agency. No consideration is necessary to create an agency. Section 185. So D is correct. D is the answer. Next is 81. Offer or proposal is defined in which section? 2A of Contract Act. A is the answer. 2B is promise. 2D is consideration. 2 is agreement. Next 82. An agreement not enforceable by law is void. C is the answer. Where is the definition? Section 2G of Contract Act. Next 83. The communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. B is the answer. This is section 4 of Contract Act. Next 84. Which statement is not true? A proposal is revoked by the communication of notice of revocation by the proposer to the other party, या फिर is revoked by the lapse of time prescribed in such proposal for its acceptance. This is correct. This is correct. Proposal is revoked by lapse of reasonable time if no time is prescribed. It is also correct. A proposal is revoked by not meeting at time prescribed. This is not true. D is the answer. Next is 85. The acceptance must be received within a week, fortnight, absolute and unqualified. C is the answer. This is section 7 of Contract Act. Next 86. Who is competent to contract? Person of unsound mind? No. Who has not attained majority? No. Who has been disqualified from contracting by the court? No. Person who has been debarred from contesting any election. He can do contract. He can do agreement. D is the answer. Next 87. Consent is said to be free when it is caused by coercion? No. Fraud? No. Mistake? No. Voluntary will of the parties. D is the answer. Consent is defined in section 13. Free consent is defined in section 14 of Contract Act. Next 88. Two or more persons are said to consent when they agree, या फिर they agree upon same thing, या फिर they agree upon the same thing in the same sense or at the given location. No. C is the answer. Next 89. When consent of an agreement is caused by coercion, the agreement is voidable contract. B is the answer. This is coercion is provided in section 15 and this is mentioned in section 19 of Contract Act. Next is 90. An agreement is void if the consideration is unlawful in part. Yeah, it can be. If the consideration is not provided by the parties, that is obviously it is void. Agreement without consideration is void. If the consideration is to be given in future, that is not void. If the consideration is paid in the past, that is also not void. So there are two options and that option was not proper, so this question was also deleted. Next 91. An agreement in restraint of marriage is void. B is the answer. See, I have made a formula and each and every single video, whatever exam it is, this question always comes and I have made the formula like this: CMTLUW, CMT love. So from 24 to 30, all agreements are void agreements in Contract Act. 24 about unlawful object. Okay, so consideration without agreement 25, restraint of marriage 26, restraint of trade 27, restraint of legal proceeding 28, uncertain 29, wagering 30 though. So all these agreements are void agreements. So you can learn this formula and whenever you're going in the exam, just write it over there in your question paper rough page, because in every question paper you will get a rough space, so you can just go in the exam, just mention it over there. It will hardly take 10 seconds. Next is 92. A contract to pay B a sum of rupees 20,000 if B's house is burnt. This is a contingent contract. B is the answer. And this is illustration in section 31, contingent contract. Next 93. A agreed to pay B a sum of rupees 5,000 if two straight lines should enclose a space. This agreement is void due to impossibility. This is illustration A in section 36 Contract Act. Next 94. A and B make a contract grounded on the erroneous belief that particular debt is barred by Indian law of limitation. This contract is not voidable. It is mentioned in section 21 and the option was not there. This question was also deleted. Next 95. A, who is B's Mukhtar, promised to exercise his influence as such with B in favor of C and C promises to pay rupees 20,000 to A. The agreement is. Next 96. A pays rupees 10,000 to B for manufacturing a machine. When it is partly manufactured, the contract is discharged by frustration. What is the remedy available to the parties? A can recover rupees 10,000 from B. Obviously, this can happen. B need not pay any further amount to B. This is also correct. B can return 10,000. No. So B is entitled only to the expenses incurred before the time of discharge. This is also correct. So there are three options are correct and one is wrong. So they should have asked like what is not a remedy available. So I would say this question was also wrong. Next 97. Liquidated damages is essentially a payment of money stipulated as a warning to the offending party. No. Payment of compensation determined by the court. No. Compensation arbitrarily determined by the aggrieved party. No. Genuine covenanted pre-estimate of damage. This is liquidated damages. So D can be the answer. But in one sense, if you see, it is also a payment of money, estimate of damage, yes, and stipulated as a warning. If let's say this party A giving warning to party B, by B, if you broke the agreement, you shall pay this amount. So this could also be the answer. Many questions are controversial questions. Next 98. Where there is a breach of contract, special damages are awarded. All right. In which case? In all cases, no. Only when there is special circumstances, no. When there is special loss, no. Only when there is a notice of the likely special loss. The breaching party knew that the other party would suffer a special loss. Only in that case. D is the answer. Next 99. Now the list 1 list 2 match करना है. Carly versus Carbolic Smoke Ball is a offer at large. Fisher versus Bell is an invitation to treat. Tin versus Hoffman, cross offer. Harry versus Facey, quotation of price. So 1, 2 and 4, 3. A is the answer. Next is 100. Madhukant Pathak versus State of Jharkhand through vigilance was decided by Jharkhand High Court in July 2017 and it pertains to tender. So this was asked in recent cases of 2017-18 है ना. So B was the answer. So keep preparing for the recent cases of Jharkhand High Court as well. So friends, here we have discussed all the questions of Contract Act which came in the exam paper of Jharkhand Judicial Services from the year 2008 to 2018. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो उसको ज़रूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. तो काइंडली गिव अस अ सुपर थैंक्स. सो फ्रेंड्स, थैंक्स वेरी मच फॉर वॉचिंग दिस वीडियो. थैंक यू.